Trayvon Martin, Jordan Davis, Joe Horn, Byron Thomas, Bo Morrison, Daniel Atkins Jr. What do all these people have in common? All of them were involved in a case where the Stand Your Ground law played a key factor in determining their guilt. Stand Your Ground law requirements vary across the states which enforce it. Although all of the Stand Your Ground laws across the country embody the same basic concept, there are some with key requirement differences that can change the outcome of a criminal case in that state, and I will show you how this can occur by providing some examples. Just over the past 5 years, there have been many very controversial cases involving the Stand Your Ground law. For example, the Trayvon Martin case in Florida became very popular because people never heard of a law like this, and people had never heard of a case like this. Many of the cases that involved Stand Your Ground laws in the past were situations in which anybody could have been a victim and anybody could be a defendant. I have researched this law extensively and found quite interesting facts about the differences in the requirements for the law in each state that enforces it in order for it to be used and tried. Before applying the law, one should understand what exactly the basic concept of Stand Your Ground laws are. Stand Your Ground law is a type of self-defense law that gives individuals the right to use deadly force to defend themselves without any requirement to retreat or evade from a dangerous or potentially lethal situation. The Stand Your Ground law acts as a defense or immunity to criminal charges. 46 states in the United States have adopted the Stand Your Ground law, which states that a person has no duty to retreat whatsoever when their home is attacked. 22 states go further, thus removing the duty of retreat from different locations outside of the home. There are many different versions of the Stand Your Ground laws across the country, and some of them have different requirements to have to be met in order for them to be used and tried. So let's start with Florida. In Florida, their version of the law states that a person is justified in the use of deadly force and does not have a duty to retreat if he or she believes that such force is necessary to prevent imminent or great bodily harm to himself or another. Also in Florida, there's an immunity provision which protects a person from prosecution for his conduct if he can make a reasonable claim of self-defense, i.e. the Trayvon Martin case. In Texas, their version only allows a person to use deadly force when they are defending themselves from deadly force from an attacker in their home, vehicle, or place of employment, or against attackers who are committing crimes of kidnapping, murder, sexual assault, or robbery. But it is not permitted if the actor provoked the other's use or attempted use of unlawful force unless the actor abandons the encounter or clearly communicates to the other his intent to do so. Let's go to California. In California, their version of states that a person is only allowed to use deadly force that a reasonable person would believe is necessary in the same situation if they are protecting themselves on their own property, like home, the car, and their place of employment. Now we're going to take it to Georgia. In Georgia, their version states that the person is not permitted to use deadly force if they are the aggressor or provokes the use of force used against them. To help you all further understand the law and show how it applies, I've come up with some examples of how law requirements differ from state to state and how that will affect the verdict in a criminal case. So we're going to use the Trayvon Martin case since everyone's familiar with this. So say this Trayvon Martin case was tried in Texas. There might have been a different result. According to a Texas version of the law, George Zimmerman would have had to prove beyond a reasonable doubt that Trayvon Martin was committing a robbery at the time of the incident. And if the jury thought that Zimmerman provoked the argument without trying to flee or communicate his intent to do so clearly, then Stand Your Ground law would not justify his actions. Now we're going to take this case to California. In California, if this case was tried, Zimmerman would not have been able to even use the law because, as I stated earlier, California's version limits the law to the person's home, car, or office of, place of employment. Neither of those were the setting of this incident. Now let's say we were in Georgia. If the jury thought that Zimmerman provoked the use of force against him, then the Stand Your Ground law wouldn't apply at all as well. So in all these hypothetical cases, you can see how one sentence provision difference can change a controversial case like the Trayvon Martin case, depending on the state. In conclusion, Stand Your Ground laws differentiate depending upon the requirements of the state in which the case is being tried and how the facts of the case relate to that law. Although all of the Stand Your Ground laws across the country embody the same basic concept, there are some with key requirement differences that can change the outcome of a criminal case in that state. And I showed you this through these, how this can occur through these examples. Stand Your Ground law requirements vary across the states from which enforce it. Any one of us could be a victim of Stand Your Ground law. And a way to defend ourselves would be to stay up to date on the types of laws that are subject and enforced in the state in which we reside.